Hi, everyone. I am Michael Hernandez with Bow River Law. We are an employment law firm here in Calgary, Alberta. And today I want to discuss the case of Calkins and Broadview Homes. This case demonstrates how lack of intention to discriminate does not excuse discrimination. So in terms of a brief background and the basics, Broadview Homes terminated Mr. Calkins after about 2.5 years due to numerous customer complaints regarding his performance and his behavior. Mr. Calkins had chronic traumatic encephalopathy. My apologies if I've mispronounced that, but it's better known as CTE, which is actually the disease that we see present in the movie Concussion, where Will Smith stars in the movie. So Mr. Calkins revealed to his supervisor a month before his termination that he believed that he had CTE. And despite this, Broadview Homes claimed they didn't know about his condition when they did terminate him. So Mr. Calkins filed a complaint with the Alberta Human Rights Commission, and before the tribunal found that Broadview should have inquired into whether Mr. Calkins' performance issues were due to his medical condition. Now, given the nature of his symptoms and his mention of CTE, the tribunal found that Broadview, even though they didn't intend to discriminate, their failure to make the connection and inquire into his CTE led to discrimination and the termination. Now, this case underlines the concept of something called the duty to inquire, which comes into play if an employer suspects that an employee's work performance could be impacted by a medical condition. If that is the case, the employer has the responsibility to inquire about the employee's health before taking action like termination. This case shows us that the duty to inquire exists even when the information about the disability is not explicitly detailed by the employee. Despite Broadview not considering Mr. Calkins' CTE in their decision to terminate him, his symptoms, which were likely caused by his CTE, did actually lead to his performance issues and ultimately his termination. So although the termination was done without an intention to discriminate, it was found to be discriminatory as Broadview didn't make the necessary inquiries into his medical condition affecting his performance. So the key takeaway from the case is that, again, there doesn't need to be an intention behind any kind of discriminatory action. It's not necessary to find that an employer actually intended to discriminate when they effected a termination or demoted an employee or made any kind of significant change to the terms of their employment. Because of this, employers must be diligent and proactive in understanding the potential impacts of their employees' health on their work performance. And if they do have any suspicion that there may be issues with regards to mental health, it's very critical that we do inquire into the potential issues, relating to the performance issues. This is obviously a very complex topic, and if you are an employer and you may be dealing with something similar, it's important to seek out legal advice, not only to protect yourself, but to ensure that the individual is being protected and his human rights are being protected as well. If you have any legal concerns in this area, make sure to, again, reach out to a legal professional.